If you're charged with drunk driving in Massachusetts and you decide to take your case to trial, the last hearing that you'll have before your trial is the Trial Readiness Conference. So the Trial Readiness Conference takes place a month or two before the trial. Its purpose is to allow the Commonwealth and Defense Counsel to file their motions in limine. These are motions regarding evidentiary issues that are going to arise or likely arise at trial. There are certain Trial Readiness Conference motions that you will see filed again and again in OUI cases. There is the motion to exclude the horizontal gaze nystagmus test. If you're stopped for drunk driving, the officer will very likely ask you to take a field sobriety test. And one of the first tests is the horizontal gaze nystagmus test, or the HGN. This is when the officer uses his pen or his finger or a flashlight, and he asks you to follow whatever's in his hand as he tries to look for nystagmus in your eyes, which would be an indication of impairment. The officer cannot testify to this at trial. There are dozens of reasons why you might have nystagmus that have nothing to do with alcohol consumption. And the officer is not a medical expert, and he cannot testify to the results of the HGN test. So in almost every OUI pretrial conference, there will be a motion to exclude that test from trial. Next, defense counsel will almost always file a motion regarding the portable breath test. So there's the breathalyzer that's used at the police station that is generally a pretty accurate test. But there's also this thing called the portable breath test, which is a little handheld breathalyzer that the police use often roadside. They'll ask you to do the field sobriety test, and then they'll ask you to blow into a handheld breathalyzer test, the portable breath test. The portable breath test is not accurate enough to qualify as a chemical breath test under the Massachusetts statutes. Therefore, the portable breath test is usually excluded from trial, but you need to file a motion asking to have it excluded. Now, if the defendant did not take the portable breath test and refused the portable breath test, there should also be a motion filed to exclude his refusal to take the portable breath test. Next, if the defendant refuses the actual breathalyzer at the police station, his refusal should also be excluded from evidence. So at the Trial Readiness Conference, you would file a motion in limine to exclude the defendant's refusal of the breath test or the breathalyzer. And then lastly, and this is a very general motion that's filed at almost every Trial Readiness Conference, you should file a motion to sequester witnesses. With an OUI arrest, there's usually a couple of police officers involved in the arrest, and the Commonwealth will summons 2 or more police officers to testify. You should have them, the ones that are not testify, sequestered. In other words, out of the courtroom while one cop's talking, and then that cop will leave the courtroom and the next cop will come in and testify, so that they're not influenced by each other, and so they don't know what sort of questions you're going to ask. I've written a blog post on this, and I'll put it in the description below.